D&B, there was a short section in relation to the Standard Building Contract, SBC 2016, relating to design. Of course, elements of that. What we're looking towards is the principal point of to reiterate the contract formation, the issues that arise from how the problems are generated later on. Certainly as a solicitor and a civil engineer, most of these areas, they are repeating. The problems that we face, or the problems that we come across or we have to be involved with, we generally find that they are repeating points. And the overall goal, one would suggest, is that if we can understand what the repeating problems are, then the key thing is then to address those points going into future or numerous contracts in the future, having taken the back analysis of where the different issues arise. D&B is obviously clearly a very, very popular over a number of years. I suppose like in the last 10 years, there was a certain format where parties had returned somewhat to a traditional format in some respects. And we often see that most developments would be undertaken within a design and build aspect. There's a lot of confusion in terms of what a design and build contract actually means and what it sometimes is brought about. Generally within disputes, within designs, what has been undertaken as a design. And critically as well, I believe that most employers could be guilty of suggesting that once it's a design and build, it's a one catch-all statement. It is the design and build contract. It's your design. You get on with it. I think is a very common process. Earlier as well, I described how I'd come across a dispute, and it always resonates in my mind, some 3 years ago, where there's certainly a significant delay suffered by a contractor. When it was actually examined what the delays were, they actually extended into design approvals and how designs were actually going to be approved for a specific element throughout the course. What actually occurred was that the drawings were not actually being approved simply on the basis that the architect in that instance had not approved because they didn't like the layouts or didn't like how the information was being presented. And that is completely in direct conflict, if you like, from what actually design is required. Remember, the obligation is to carry out the design, reasonable current skill. It's not there to inherently, it's there to be discharged. What is the design? And once the design is capable of being put in place, that is the underlying obligation, and those obligations rest with a contractor in this instance. So if we begin to the instance, then if we always go back to the articles in this point, and if we think about the JCT design and build, or the SBC, or any of the JCT suites, the first point about it is that, like, no, the underlying question is, what is a contract? And it's in most simplistic terms. If we look at the JCT, we have in particular two real primary areas of the contract. Of course, the schedules form the third part as well, importantly. But if we look at what the two distinct areas are, we have the agreement, which is made up of the recitals, particulars, and the articles, and then we have the conditions made up of 9 separate distinct parts. If we are to say that the agreement sets out what the parties intend to be discharged, what the parties intend to be built, and for how much, then we might consider to say, well, the conditions set out the course of conduct of the parties to reach that. And that makes complete sense. Like, if we look at the conditions, it's set out in 9 distinct areas, right the way through from definitions, interpretation, to carrying out the works, control the payment regimes, changes, variations, right through to third parties, right through to disputes. And of course, we have section 8 under the standard form, which is termination, if we actually have to envisage a discharge by breach as opposed to a discharge by performance of the contract. So it's a very much the conditions, they set out the course of conduct. And the agreement itself, especially in these forms of contract, when we look at towards what the employer's requirement, in its most simplest manner of speaking, the employer's requirements set out what the employer wishes to be built and to what specification or what standard and for how much. And of course, invariably, the contractor's proposals is how does the contractor intend to actually go about this to reach the employer's requirements. There's absolutely no harm in looking at it in its most simplistic nature, because then we can treat that as the baseline, the first principle approach, and then we can engage in whatever issues arise thereafter. But in most simplest approach. But if that is true, and that is the way the contracts are viewed, it's pretty incredible that we consider that most contracts, therefore, are placed into a drawer, or it's nearly akin to break glass in the event of a dispute. And this is often not the way they actually transpire. But critically, it's actually to use the contract as a guide route, and certainly as a set of obligations to discharge, so that the project can actually be formulated. Like a lot of different times, the problems generally manifest themselves and they actually become very crystallized during the tendering process, right up until the time of the formation of the contract. And generally, we will always find that if the dispute does occur, one of the first questions a lawyer or anybody deciding on a matter will always have to really establish is, what was the basis of contract? What was the clear intention of the parties at the time of contract? And what were the distinct terms that they agreed in order to reach the outcome? So whilst the pragmatic nature, and we still have real issues in this industry surrounding how we tender, the timeframes, the uncertainty, the price-driven positions as well. But inherently, this is the occasion that most, if not all, of the issues are actually created for. And these are the certain issues that we face within the industry. So overall, if we have a clear understanding about what is contained within the EORs, how the EORs sit within the contract documents, we'll a little bit about the hierarchy under clause 1.3 as well. But if we go back to Article 1 is fundamental to understanding how the contract is to operate and sets out the contractor's obligations in the following terms. The contractor shall complete the design for the works and carry out and complete the construction of the works in accordance with the contract documents. And that's absolutely clear. And of course, there's going to be implied terms there as well in respect of that. If we look at the standard building contract as a base document, we'll see often that the contractor shall carry out the works and complete the works in accordance with the contract documents also. But we also take in the 10th and 11th recital, because distinctly and uniquely, and this is no different from the ICD, the intermediate contract form with design. And ultimately, the contractor, the employer is quite fine to progress the design, maintain all of those traditional aspects of hiring the consultants, producing those design works, but maintain that there's discrete elements to be undertaken by the contractor. Typical examples might be for specialism, M&E, or mechanical and electrical engineering, or certainly cladding, or really discrete areas where the specialisms can come into play. So, but overall, what's really important is that regardless of the form of contract, if there's a CDP element or if it's a complete design and build, the real issues really surround the like liability, and that if you are undertaking design work, that you carry that professional indemnity, you have the like liability of any architect or any consultant carrying out those works as well. So in full form as well, it is the contractor that is responsible for the design. Yes, there are approvals, and we will talk very shortly about the approvals when we talk about the schedules in Schedule 1. But when we actually consider, it is for the contractor in these discrete areas who is wholly responsible for the design. the integration, the coordination of those designs will invariably always become a point of contention, and we see that very, very often. But it will be, the responsibility sets out that, of course. So if we look at the contract documents, if we define them as clause 1.1 as being the agreement, so we've already said the articles, the recitals, setting out inherently the specific natures of that. That's the agreement, that's the expectation reliance, that's the bargain to which the employer has bought and is willing to pay the price for the end results. The conditions, the course of conduct between parties, and we see the 9 sections of those as well. And of course, the schedules then remain. But inherently, what now becomes critically important is the employer's requirements, contractor's proposals, and the contract sum analysis. They're the 3 elements now that surround and become quite important, obviously, with design build. Now, for the employer's requirements, whilst most forms, JCT can be very traditional and anybody who regards the points of programming, there's no set procedures in terms of the points of how programming is to work or how it's supposed to be displayed. But what we actually have is the employer's requirements. The JCT does not necessarily set out to what level of detail. So one might suggest that if it's one line to suggest, well, build me a house, that is in itself capable of being an employer's requirements. Now, what the inherent details of that, the size, the nature, extent, the quality of materials, they might be all ignored, but once the contractor undertakes the design to that respect. So realistically, we know that that's not a very good set of employer requirements. So how do we treat this? And over the course of events, we'd see that parties will then go to the instance of developing out to a stage. They might suggest, well, they will take the design forward as an employer to stage 3 or 4 of a REBA, stage design. And with typical, they might suggest innovations at this point, or that the contractor is free to take those designs and employ their own consultants. This is where we find one of the key difficulties later on. What if the employer's requirements were actually wrong in terms of designs that was carried out up until that stage? Most parties at this point will also believe that once it's incorporated and the EORs are incorporated, that all responsibility for all design rests with the contractor. But we make reference to it later, but I certainly will bring the point now. This is expressly dealt with under the JCT in Section 2, specifically between sections 2.8 to 2.11, in particular 2.11. The real nature on an unamended form of conditions is really that the contractor is not responsible for the contents of the EORs or any design contained within them. And this is a really misunderstood point. Now, amended forms generally deal with this point if it's done correctly. But one of the starting points is that a contractor must ask itself to say, are we actually responsible for the contents of the design if they are not workable or if they require a change, or what are the given natures? So in response usually to the employer's requirements, a contractor will generally put forward their contractor's proposals. Again, we have another instance. What does the contractor's proposals actually look like? Inherently, in the most simplistic sense, the contractor is to propose what and how they are going to undertake the works so that they discharge what's required of the employer's requirements themselves. We then have an instance whereby, what if the contractor's proposals do not meet the employer's requirements? What if the contractor's proposals identify something that actually the employer's requirements haven't? Again, these are the points. So it's understanding when those baselines are set in place, what is the actual true course of nature, what is the answer in those respects as well. With contract sum analysis, obviously is setting out. One of the critical points is who prepares the contract sum analysis. Most consultants, especially for comparative analysis between tenders, will always wish to set out a degree of what is to be priced, the rates, quantity on those elements. But we now have an issue, because if we're going on a specification base or design, or we're now looking towards those points, it's development of that CSA. Because critically, it could be that those who create the CSA may be responsible for its contents, particularly depending on how the contract is actually brought about within either A or B. So due regard needs to be brought through. So if consultants do like using the comparative analysis to compare and adjudicate on different tenders of what different contractors are actually proposing, it's very, very important to realize the liability that actually rests. Furthermore, we often see that employers' requirements contain further, if you like, conditions of how the works are to be undertaken, either in risk allocation or in certain works to be undertaken. What really becomes important, and I'll mention it now, is clause 1.3. Clause 1.3 is a very innocuous, small clause, but it's inherently important. It actually sets out the hierarchy. Usually this is developed out, and most people will be aware of the different hierarchy clauses that can be actually introduced in terms of if there is a discrepancy. What actually the standard form suggests is that the agreement is to be read as a whole, but nothing in the EORs or nothing in any particulars is to override the contents of the agreement or the conditions. So therefore the conditions and the agreement is to be read above any of the EORs. This becomes a moot point, because if the EORs have set out a particular requirement, but the conditions or the agreement have already dealt with that, immediately then the agreement and the conditions take precedence. So in the formation of the contract, it's always worthwhile looking at to understand, do any of the conditions go against or offend, or do they conflict with any of the purpose of the EORs? Mostly any amendments done to the conditions might be by one party, usually lawyers, but certainly the EORs will be developed by the consultant team to make sure that they're aligned, to make sure that they are not at cross purposes, because otherwise there is a real risk of destroying the intent potentially of the EORs on that instance as well. And so that becomes very, very much obviously qualifications in contract sum analysis as well. If it's dealt with in the conditions, then it's the conditions that one must actually address to make sure it's enforceable. So in the SBC, the standard billing contract, contract drawings, the agreement, and these conditions, together with the EORs, the CPs, if option A, the pricing document, option B, the specification, and of course, the fluctuations if they apply. The intention is that the employer should set out the requirements on whatever degree of detail considered appropriate within the employer's requirements. And that's easier said than done. As we mentioned, there is no set format. It is a question of degree. How far a design has actually progressed before it goes out to tender. Clearly, the more detail, clearly the more of a direction and a roadmap as to how this project is to be built and designed, clearly does help with the price certainty. But the clear indications of the more and more, and in the absence of any amended terms, then we're looking to say is the risk associated with that prior design on an unamended form will rest within the areas that we already mentioned. Contractors should respond to these with the contractor's proposals, setting out the manner in which it proposed to design and construct the works. And again, we have certainly within the recitals a term which the employer has examined the contractor's proposals and they appear to meet the employer's requirements. Always remember that the term is very explicit. They appear to meet. It does not suggest that they do meet. It says that they appear to meet. Design responsibility rests with the contractor wholly. So in subsequent arguments to suggest that the employer did accept, or that they did accept the design, and they tried to rely upon these words that they did inspect them, they did appear to meet, is not a particularly robust defense. Ultimately, design responsibility rests with the designer, which in this case will be the contractor taking it forward. Again, this is repeated in the schedule as well, Schedule 1. Depending on the procurement approach adopted, the level of detail within the employer's requirements may vary between a performance-oriented statement of objectives and a detailed and prescriptive statement of what the contractors provide. Similarly, responding to the degree of detail within the employer's requirements, contractors' proposals may contain the result of a substantial design development work, may simply be a reiteration of the employer's requirements. So where we do have amended conditions or we do have agreements, we're now in the relationship of the interrogation of pre-contract. Most formats at the moment, we often see it quite regularly on an amended basis, is where the employer's requirements are simply adopted as being the contractor's proposals. And we often wonder, has the necessary interrogation on the basis of what the words say does not always reflect naturally what the contractors would have always suggested. They will always suggest that they have their own methods, they have their own works and how they intend to progress the design. This clearly conflicts with a point, perhaps, that they've adopted the employer's requirements as being the contractor's proposals. So due care and attention is to be taken at that time. If the approaches towards design and discharging the contract are of a particular nature, that they are crystallized, they are set out, and they are made express during that point of time. Sitting closely with the obligations as a whole, Clause 2.1 becomes very much the forefront. It's one of the first clauses, of course, within the contract. Under the D&B, the contractor is prohibited from undertaking any work for which it is necessary to produce design documents until such time as he complied with either the design submission procedure set out in Schedule 1, or such other requirements are stated in the contract documents as stated in Clause 2.8. So realistically, we're now talking about how is design actually undertaken throughout the course. So we've accepted that the design elements are there. And I repeat back to earlier my point, this is generally one of the areas of contention when a design can be approved, when it is approved, what status does it actually reach? Remembering as well that the contractor is inherently responsible for the design of the requirements. So when we look towards Schedule 1, and it's generally not used quite to its main purpose, I would feel. I would also suggest that generally programming, and certainly the first program of the contract, should, under JCT, set the baseline for all subsequent activities. But we always have habits within the construction industry, and they are usually reflect in the baseline contract. They usually reflect the actual construction activities themselves. For some reason, not taking into account the inherent nature of the design elements that really lead to those points. So the activities surrounding design elements, between approvals, between actual generations of designs, they're naturally just as important. And we don't really see the intensity of including design provisions and design procedures, especially if we do mobilize Schedule 1 of a design acceptance procedure within these contracts. That inherently becomes quite a large problem, because while one design is being held up for whatever reason, we're now into delay points. And I do really regret to say that a lot of contractors, they don't understand these points of when or how, and they lose much time, especially in the initial stages of the project. And what we usually find is that the final third of the project is when the disputes really crystallize. and by that stage, it can be far too late to back analyze the delays that were actually caused by non-approvals. And if the non-approvals were correct or incorrect, it's far too late at this stage to be analyzing it. But where Schedule 1 is applicable, if the contractor fails to comply with the procedure, he's not entitled to be paid for the work so executed. So it's a two-way street in that respect of the design procedure. But if the design have not been approved, the works carry on, then we don't actually see that as being a reason for quite a lot of pay less notices. That's one aspect I wouldn't be as regular to see when they are generated. But again, this is back to pre-planning. This is before the incorporation of the documents, the contract. And right at this very moment in time, there really is not those intense conversations about how is design going to progress to actually discharge the activities themselves. And it really needs more discussion on those points. So what does Schedule 1 realistically provide for as a summary? The contractor submits the design documents to employer. Within 14 days, we have three status. It's either approved, it's a B, comments, but can proceed, or C, rejected to submit. And the C element of resubmit is quite an interesting one, because we're now into what would become possibly a subjective nature. Ultimately, if the contractor has discharged the design and carry out the design, then the contractor has complied with the contract. It has fulfilled the design. The design has been carried out with a reasonable care and skill in accordance with all specifications, with statutory requirements if necessary. So realistically, whether or not it becomes a subjective nature, you're now asking a real question of whether or not the employer's requirements has changed. Because once the design has been carried out at that point, then the obligation to carry out the design has been. And I refer back as well to the dispute some 3 years ago that I was involved with, where delays were caused about non-acceptance. In fact, the specific reason that was given at the time for rejecting the M&E drawings was because that the drawings did not actually carry the adequate color coding or labeling on the drawings. Had the EORs called for that, then it would have been a requirement. There was no evidence of any requirements to actually go to such detail on the actual design drawings. So if the contractor then disagrees with the employer's requirements, then they resubmit. And these are all elements as well that you actually then contain, that they actually then roll on through, like, in terms of timelines. This again can be fed back into a program. This is effective delay analysis. This is something that realistically is not seen often enough, that it is the impacts of design developments throughout the course of a project really is not analyzed, and it's really not taken into account. The concentration, of course, is always on the ability to carry out the works, the physical works. It's very real, it's physical, we can see that progress. But in the background, the decisions that inform those really don't get the treatment that they often require in programming. The contractor is required to undertake any design work to the standard expected of an appropriate professional consultant, such as an architect or consulting engineer, appointed directly by the employer, and not undertaking any construction work. So this is like liability. So if you're going to be a contractor, if you're going to carry out a design and build role, we are now looking at the instance where we're saying, well, my obligations are that of what would be, if there was an external consultant, reasonable care and skill, for example. The provider of insurance, that there is professional indemnity. And inherently, this becomes a point of due diligence. So if we now examine a contractor who's going to undertake a design and build, is this a contractor who has that level of experience? But not only that, does it regularly carry professional indemnity insurance for these particular types of works? If this is a one-off and the contractor has never done it before, there certainly should be for due diligence, because we're now facing the point to say, well, if the professional indemnity what do we do now about the limitation period? So we've reached practical completion, but what provisions are in place with professional indemnity for the next number of years? And I don't feel that question ever gets asked enough, because this inherently, if there is an issue with design, and one might say that if in the absence of any collateral warranties or third-party rights, that there is a negligent design, and it's claimed for by the employer, assuming that all the parties are in place some years down the line. But the chain of privity could easily be broken, or the recoverability. So those periods of time to understand that these insurances are, how they're maintained, when they're maintained, and to what extent, and when the claim can actually be made. So certainly the question relating to contractors is what experience, what level of PI, what extent are these works that they carry out ordinarily and continuously. If it's a one-off, then further questions need to be asked. The contractor needs to ask themselves at this point to maintain that type of level of insurance for commerciality going forward as well as an ongoing business concern. In completing the design of the works, the contractor is not required to take responsibility either for the contents of the employer's requirements or for verifying the adequacy of any design they contain, save only to the extent that they conflict with statutory requirements. And this, as I've already said before, clause 2.11 on the unamended form, granted that amended forms of contracts will usually reverse this point distinctly and uniquely, but this is very, very much misunderstood. It is usually the point that parties will presume at this stage that once it's design and build, all design contained. And that's not necessarily true. So we have the conflicting nature of this. How far does an employer progress their design pre-tender or pre-contract in order to give that price certainty, clearly with the risk of any designs that may not be right, for price certainty versus the contractor then making such allegations. Now, of course, we can amend them. It's a very common express clause that all of the contents of the employer's requirements. But even in the unamended form, it's not readily understood. And this is certainly an area that contractors miss. They are generally of the understanding that all consequences of all design failures of time, money, implementation of designs, delays occurring with those designs or redesigns is all of their issues. The one exception, of course, is going to be statutory requirements. But the provision of clause 2.11, the most natural point was to actually look back towards 2002 case of cooperative insurance versus Henry Booth Scotland Limited. If the contractor does identify a deficiency in the employer's requirements, and the deficiency has not been addressed by the contractor's proposals, then the employer's requirements are modified accordingly, and that modification is treated as a change. That's the result. So the proper application of clause 2.11 is that it's treated as a change or variation, in other words, as well, under section 5. In the case of cooperative insurance, there was a positive obligation that on the contractor to take all of these instances in place. But in MTH, a unanimous decision, the Supreme Court ruled that it was liable for breach of the fitness for purpose obligations construed either as a warranty that the foundations would have been a minimum service life of 20 years, or they would have been designed to last at least 20 years in that particular case. Subject to all monies due under the contract having been paid to the contractor, the employer is granted license to use the contractor's design documents for any purpose relating to the works, although the copyright in these documents remains with the contractor. One of the main areas, again, this is a very heavily amended clause in terms of payments and how payments rise. what generally we would find the main discrepancy, the main source of disputes are when we deal with termination clauses with particular consultants, or when we deal with termination clause well before the actual discharge of the contract. So that area generally, in fact, termination as a clause as a whole does not get treated with the same application as you would certainly see with Section 2 or Section 3. And parties, be it one way or the other, they always foresee that everything will work out well, but termination is a fact of life. Parties do fall out for whatever reason, including insolvency. But this is one of the key areas, is the copyright and the license to use. And following termination, the question must stand: is it now upon there's a dispute over payment, there's outstanding fees, and for a length of time that will take quite a bit of time to actually run its course. During that period of time, of course, what are the employer's options? Do they have to restart the design again? Can they adopt? What can they do? Or if they've made part payment, even though disputed? These are elements that really ought to be, because it can cause significant delays, it can cause significant costs as well associated with those points as well. So the treatment of design documents themselves, or intellectual property rights concerning those, do have a very, very physical bearing on the operation in the event, especially of termination. So if we look towards where we the conflicts of how the EORs and the CPs, how certainly conflicts arise between them. What we have is that we might have conflicts or inadequacies in the EORs themselves. Simply put, certain items might have been missed or might have not been expressly stated, or there are two separate elements that simply are unworkable. The position is quite clear on this point, and we go back to clause 211. What we're actually suggesting is that it might be the case that the contractor's proposals actually highlight this, and maybe the contractor's proposals are actually the correct way to address the point. In that instance, a change is actually to be instructed, and the contractor, of course, will gain the necessary time and expense with that. True to form, if we have the inadequacies within the contractor's proposals and they're identified, well, of course, an instruction will be issued to the contractor to correct their contractor's proposals. But of course, as you'd imagine, if they don't meet the or they're not in compliance with the employer's requirements, well, at that stage, then there's hardly any call for time or money in that respect as well. More of what can happen actually is conflicts between the EORs and the CPs, between them, in and between themselves, that amongst themselves they seem quite workable. They generally conflict or for different reasons and can be quite subtle. And that is a nature of actually stripping it down to its base, and it's an argument on facts of what they build up. This is the area where one might suggest that there can be a common or mutual mistake between parties, that there are cross purposes, or indeed, but ultimately it's about breaking down what the both parties had intended at the time of contract. But importantly, and it's an exception that must be actually taken very much to point, is the statutory requirements, a term which includes development control requirements. The contractor is required to carry out and complete the works in accordance with the statutory requirements, including giving all necessary notices, except to the extent that the employer's requirements specifically state that any part of those requirements comply with the statutory requirements, where they've actually made that express statement. Where there's a discrepancy between the employer's requirements or the contractor's proposals and a statutory requirement, then the contractor is required to propose for the employer's agreement an amendment and then complete the design and construction of the works in accordance with that amendment and entirely at their own cost. So the key element that must be recognized in this phase of this discussion is that a contractor, being a competent one, must understand what its obligations are in carrying out works in relation to statutory requirements. the most basic element, of course, would be carrying out work safely. For example, there is very little point in the contractor putting forward a design or a process or methodology of design which completely offends the Health and Safety of Work Act 1974. So taking that presumption, taking that as an example, and that then transpires onto all other statutory requirements, there's a positive obligation on the contractor to understand what and what not it is able to do in respect of to carry out its works in accordance with those statutory requirements. Another example would be, of course, like to carry out works in accordance with building regulations, and that understands what nature of the statutory requirements actually affect its works. The differences, of course, will be, on the first point, the statutory requirements change after the base date. So the base date is a date that sometimes is notional, and other parties apply their mind to. But if we have all the tendering documents, we are looking to progress to formalizing a contract in relation to the works. What have we actually based our contract on? What documents? So therefore, anything, if we now understand that any statutory requirement that changes after the base date. So the selection of the base date is critical in terms of what status of our approach to the overall contract will be. There's very little point in selecting a base date that is completely wrong and completely at odds with our approach. So that selection is important, and again is to be repeated. We've often seen that the base date is sometimes selected as being the date of contract erroneously. But certainly it's the analysis of the overall documents, and any changes to the statutory requirements following the base can provide the redress to the contractor at a later date. Contractors' proposals require modification to comply with development control requirements, i.e. statutory provisions which control the right to develop the site, unless the employer's requirements say that such matters are at the contractor's risk. This provision is intended to recognise the fact that if the contractor is appointed before full planning permission is obtained, there may be unforeseen conditions applied by the planning consent. It is necessary to alter any part of the employer's requirements which the employer has expressly stated to be compliant with statutory requirements. It frequently occurs in practice, particularly in engineering contracts, that unexpected difficulties are encountered during construction, which may not only necessitate a change from the expected method of working, but in extreme cases may mean that completion of the work, at least in strict accordance with the original design, is impossible. Many contracts contain express provisions making such risks or contingencies the responsibility of the contractor. These can take the form of, for example, express disclaimers as to the state of the site and the physical conditions or dangers generally, and also the provisions for the protection of the works during construction. And these are very usual as amendments, which generally then go to reinforce those points. Earlier, I discussed about, for example, in substructure works, where we're now relying upon site surveys, or we're relying upon borehole geotechnical data, for example, on any subsequent designs that a contractor would carry out for those substructure works. Mostly in those cases, the geotechnical company will be employed long before any tenders have been submitted. The assumptions, parameters of design, be they K values or phi values, or bearing pressures in relation to design overall of the structure, can be actually determined long time before that. This is where the due diligence comes towards. Are we dealing with one borehole? Are we dealing with a geotechnical report that we can reasonably rely upon? Or do we now have to look towards extracting more information, or do we exclude the responsibility for that? These are outcomes that have become extremely expensive through redesign, when it has been determined that there were assumptions made, albeit qualified, as to the state of the strata of the ground conditions, for example. Again, these points come into coordination between the works generally. A lot of the instances where you will have cladding being incorporated with a superstructure, even the different elements of lift cores and the precast staircases, or who takes control of the design of those elements, of the connectivity between the two. All of these matters are those which we generally will find that fail to get determined, and they create contingent liabilities. In some respects, with the drafting, they will just immediately box in all of those risks neatly by express wording, of course. But the objective of what we're trying to suggest is that these elements should be discussed right before the time of contract. In the absence of any express disclaimer, an owner who uses a professional advisor does not warrant that the completion according to his advisor's plans or design is practicable, and that even in the absence of express provisions for the protection of the works, the risk in regard to the safety of the works remain with the contractor unless they've been reoccupied by the owner. Nor does the owner warrant that he is competent in any way, for example, in making decisions as to the contractor's method of working. And this was a case in 1958. Effectively, therefore, a contractor who, as is almost invariably the case, expressly or implicitly undertakes to complete the work or project according to the contract drawings and design, thereby implicitly warrants his ability to do so, and if he cannot, will be liable in damages. In consequence, any additional work necessary to achieve completion must be carried out by him at his own expense if he is to discharge his liability under the contract, and will not qualify for additional payment as a variation, even if he has been formally instructed to undertake that works. And the distinction, of course, between an instruction and between a valid change or variation. Remember, a change or variation is a change to the actual employer's requirements. It's not necessarily just because there was an instruction. And all too often, we've had to back analyze, go through numerous different instructions, when in fact they were exactly that. They were instructions to proceed on a different point, but not necessarily do they always amount to a variation in those instances. It follows that every invitation to tender a price for the construction of a project design provided for or on behalf of the owner is in essence therefore a double question by the owners to the contractor. Can you build this design, and if so, what price? Failure to do so, even if impossible, would place the contractor in breach of contract. And we're right back to the very start where we discussed this. What is the contract? What are the constituent elements? That if we have the agreement of what we're going to build and for how much, and if the conditions are there as the course of conduct, in its most simplest, barest form, that's essentially what we're dealing with. We might get into separate discrete elements of about incorporation, we might get into about interpretation, all of those discrete arguments about what those different points are, many of which can be resolved realistically because of the repeating nature of construction elements and contracts certainly comes to the forefront. But certainly the inherent risk that's associated with the contracting in this nature, especially in design and build, rather than just being a matter of convenience, comes to the forefront. Okay, well that's for this morning. Thanks very much for joining in. Any questions, do ask either by email or to Julie Camp directly. Okay, thanks very much.
Hi Henry, we have indeed got some questions, so if I could put these to you, that would be great. Our first question is, what is a subcontractor's responsibility with regards to design? Should they be putting forward proposals through coordination with other subcontractors, or would the main contractor put together their proposals for subcontractors to comment on?
Okay, so taking into example for the JCT format, so we might get an instance where the employer employs the contractor. The contractor is under a design and build point. Subsequently, the contractor then wants to employ a specialist subcontractor. For example, I'm thinking quite a lot of M&E, mechanical and electrical. And they may want for that subcontractor to carry out the discrete elements of those design. So elements like HVAC, MVHR, all these which are really very much specialist. So what the contractor will actually do in that instance is that it will take the employer's requirements, understand what those employer's requirements are for the specification, They will then enter into a subcontract with the specialist, subcontractor, and they will actually provide what's called contractors' requirements. And then you will have subcontractors' proposals. So in effect, it steps down. The key nature there is the coordination between what's overall required in the main contract to ensure that it steps down towards the subcontractor. Again, we're talking about insurance. So whilst in that instance, the contractor in the eyes of the employer has the like liability as we talked about earlier on, but ultimately the contractor will be approaching the subcontractor to ensure that those insurances are in place, that they are back to the same value as well in that instance. But they will also look to step down the requirements specifically to ensure that they are right, because if they get those contractors' requirements wrong and the subcontractors' proposals are going to be wrong then anyway, all that will happen is that the contractor will remain in breach for failure to carry out the works of the design under the employer's contract.
Okay, next question. What are the responsibilities of the consultant's design team, i.e. the architect and engineer, once the contractor is in contract?
In the specific terms, so where an employer actually retains the consultants of those elements. So for example, they might have engineering, or they might have an architecture role, and therefore the contractor then takes on all the design responsibility in those elements. What is the contingent liability going back to the original consultants? So on the presumption that all of the design has been contained necessary within the EORs, the contractor is responsible for that design. The specific agreement of the retained consultants, because the question now has to be raised, what is their role now? Are they checking? Are they verifying? Are they assisting the employer? We obviously go back then to say that the design responsibility rests with the actual contractor. They have to discharge the design at those points. Ultimately, we're now suggesting that, you know, back to if the employer has examined, so naturally enough, they'll use those consultants that's retained on that point to examine. But ultimately, design responsibility rests with the contractor.
Okay. If a D&B contract requires the contractors to submit an amendment to correct a discrepancy at their own cost and time, is this submission dealt with under Schedule 1, Design Submission Procedures? I.e., could they provide a proposal to amend the ERs?
Yeah, ultimately, Schedule 1 is more of a design procedure of how it's accepted, etc. If there's an actual change to the EORs and there's a proposal to change for the EORs, that's actually going to be contained expressly within Section 5, which is variations and changes. So any substitution, any variation of work to the quality or quantity of anything contained within the employer's requirements is going to be dealt with specifically within Section 5. And it's inherently within Section 5, then that relates to the relevant events, which will afford you the time. And of course, then you'll have the valuation rules, which then follow through on how to value the change to those EORs afterwards.
Okay. If the employer's requirements are effectively the contractor's proposals, do the contractor's design documents approved under the design submission procedure also form part of the CPs?
Okay, so this is one of the most common points that actually comes towards, okay, and this is where the real deep understanding, because what actually has been incorporated at the time of contract, and that's where we've got to look at, is that if the parties have contracted on a point to say that the EORs, the CPs are the EORs, or the EORs are the CPs, or vice versa. Okay, so, you know, and then subsequently post-contract that the contractor starts producing its own proposals following the crystallization of that contract, well, it has to be measured against what the base intent of the parties was at the time of contract. So if the contractor was then to plead something of the order saying, well, we didn't really understand, or this is actually how we would like to do it. It's really, does it offend, does it conflict with the existing EORs? Or is there an inherent conflict? Because that could quite simply relate back now to being a risk of the contractor. They had its opportunity, and at the formation of contract, they did accept at that point in time that the employer's requirements would be the contractor's proposals. If they subsequently changed that, they are now into a risk point that if there is nothing inherently inadequate or conflicting within the EORs, but they change, any of those changes could be potentially at their own cost and time elements.
Okay. Contractors often consider any instruction as being a change under the contract, but not every instruction is necessarily a change?
That's exactly correct. An instruction is exactly what it is. There's two positions of an instruction under the JCT. Instructions are to be carried out forthwith prior to practical completion. After practical completion, they're to be carried out in a reasonable time. But for example, not every instruction, they are inherently different, and it must be seen as different. Yes, you may require an instruction to carry out a change, like on those points, but you don't necessarily, not every instruction constitutes a change. And the argument, of course, is can you have a change or a variation after practical completion? And there's case law in relation to that. No, you ought not to. Potentially it's a new collateral contract. All the works are being carried out in accordance with the contract to reach PC, so therefore there should be no reason to actually have variation to the EORs. But not every instruction is a variation. That's critically important to understand. It can form, it can actually indicate, it can be certainly on that process. It's certainly excellent to have an instruction with a change, and so that you're not into those difficult arguments like what's a deemed variation, or retrospectively have to argue to point out. But in this notion, in this particular instance, not every instruction constitutes immediately a change. It's whether or not the EORs have been changed, or there's a change required of the EORs.
Okay. What if there are significant errors in the ERs or initial designs, e.g. the architectural drawings? Is it the contractor's express responsibility to check these before they enter into the contract?
No, not necessarily. What they do have is they have an obligation that once they become aware, they're to notify, but there's no express obligation on the contractor to go through every single EOR and to validate or verify or all of those different points. There's no express active positive duty on the contractor to check the FSC. That liability rests with the employer and the contents of the EORs. The exception being if it offends the statutory requirements. That's one of the really key points. So there's no positive duty to go and check. What they do, but once a discrepancy or that conflict does arise, they become aware of it, they do have to notify it. And if a change is necessary to the EORs at that stage to correct or to marginalize and give effect to that change, then the employer's agent at that stage ought to be issuing an instruction to change the EORs. And if that change constitutes a change of the contract, entitling to time and extra expense, then that would constitute a variation. That's the limits there.
Okay. Employers' design consultants are generally retained as design guardians during the construction phase. Can the same consultant be engaged by the principal contractor as their designers, which effectively is leading to the design consultant acting as the contractor's designer and the employer's design guardian at the same time? What are the contractual implications? Is this lawful?
Yeah, this is actually a question which on the face of it, it seems like a simple answer, but it's actually more regular than you think, whereby a party might be novated for a certain element with a contractor, but they're still retained. They're still retained by the employer, but inherently they're actually undertaking works for the contractor to continue on through design. Usually you might see that with an employer who has a previous existing relationship, has the numerous amount of projects, delivered them all quite okay. The key real point that raises in my mind there is that clearly, without going into too much to blide and blide or the no loss argument, which an employer could actually theoretically go through about who's actually employing at that stage, because you're into an argument that would actually contain under no loss argument suffered by the employer of who contracted who. But also, my first instinct is really to say as well, if they're currently and concurrently throughout the course of the project, we've got to raise, is there an inherent conflict of interest? Like it or not, contracts are a set of competing interests in many different respects. So, and I think that's when we understand those points. So invariably, a contractor will want to build for the least cost with the maximum value in the shortest space of time. And invariably, a consultant on behalf of the employer might want simply the best quality, you know, and different parties have different interests, and that's the nature of the actual agreements. So one of my first points there would be, is there an inherent conflict of interest per se, because taking two naturally. And the question there really is, you know, can they exercise independent thought to act in the best interest of their client? Or simply put, do the right thing. And if they're in any way prevented from doing so, or if they can't give that full position, then their position, they really it could become untenable depending on the extent. So it's a little bit of an unsafe area, and I have come across that quite regularly, more regularly than one would imagine. But it comes down to the relationships, and construction is one of those industries. It is formed quite a lot in relationships. It generally happens when there's an employer who generally keeps the same design team working all the way through. But not only from a technical legal argument about a no loss, who employs who approved what, where, has the employer suffered any loss in relation to that? And we are back into a Blythe versus Blythe 1994 argument on that, with the famous case that led to novations. But as well as that, I would have to suggest that if there is an inability to exercise the independence of thought and to act in the best interest of those who are employing, or if you're compromised about pushing that forward, or if you're in doubt, you could be getting quite close to a conflict of interest, which simply is not right at all.
Okay, and another one just come in here. If the tender drawings indicate a specific method of construction, i.e. a method internal skin of an external wall, can the contractor redesign to construct in timber, provided it complies with the statutory requirements?
Yeah, okay, so we're now going into the extent where parties have actually come to contract, and I like the analogy that's been given with the different materials and the different points, and I often use a similar analogy. I always use a similar analogy of a steel frame versus a concrete frame building in that respect. So let's look at the EORs, for example, for the employer's requirements. If the employer's requirements in that instance were specifically to suggest build a wall, okay, well, it's completely within the gift of the contractor to design a wall because it's so bare in its requirements. But if they build it within, say, it's retaining, or it can perform, it has those durability points, all of those taken into forefront. But if it's not specific enough to say what type of material it is, then it's completely within the gift of the contractor. If, however, the EORs are so well developed, as sometimes they are to stage 3 or 4, where it suggests, well, we want the thermal qualities of so therefore it's going to have to be C40, or even RC40, or it might have to be C50, or it might have to have certain bending moments, or it might have to have whatever different specifications from concrete, and it gets so detailed within the EORs. Those elements now are stripped from the contractor for that level of choice. So really the description and the contents of the EORs becomes really important there. on that occasion, there's nothing preventing the contractor to suggest, well, instead of building a concrete wall, I would like to build it in timber. I can meet the performance specification. It has the durability points all taken care of. All of those things I would like to, that would constitute a change. And usually that's when the negotiation points are, well, is there a cost saving? Is there a time implication? All of those events. But the really important point is how the EORs at the original stage actually directed and dictated that point. If they went into, the EORs went into such detail, even with bar bending schedules and different types of concrete, you know, you're not in compliance with the employer's requirements at that stage. If it was just simply say, build me a wall, that gives that much more latitude towards the contractor of how they're going to reach that design. But ultimately what they were doing, you would expect prior to contract formation, is if an employer suggested, build me a wall, you'd expect at that stage the contractor would actually put out its performance specification, to meet its performance specification, that would put out its detailed design and the materials and those aspects prior to contract. Post-contract, if it's all being missed, that element, again, you have to reach the specification requirements of the EORs, but that's usually when the negotiations or how it, but in effect it would amount to a change, but there's no obligation on the employer if they've been so not, specific on the EORs.
Okay, and final question. Could an employer claim for financial loss, diminution in the value of a building if a D&B contractor did not meet the employer's requirements fully?
Yeah, so ultimately, the short answer there, and there's a number of different case laws as well. If a contractor has effectively is in breach, so if they haven't carried out a design in accordance with the contract requirements, it's a breach. So therefore, losses follow from that breach upon being proved on the balance. One of those is the loss of value. So you're into two limbs. So we're back to Hadley versus Baxendale as being one element. You've got your direct loss. You got your second limb as well. So typically as well, you'd be into the second limb of Hadley and Baxendale, potentially nothing precluding from the first as well, first limb. But any losses that has arisen from a breach of that contract will be recoverable. You will generally find that it will be recoverable, usually like there will be a claim in terms of common law. Those heads would be retrievable as well. But ultimately, we're suggesting that the contractor has failed to carry out the works, is in breach of the contract, losses have been suffered. Now, the avenue that lawyers would take on that, they might even take in if the property or different elements, there's certain statutes in place as well. But unless there's a case of special knowledge, which generally there wouldn't be, like it would be very much in the contemplation of a party, that if a certain block of flats didn't have fire prevention or couldn't get building control sign-off in terms of fire prevention or fire control, they're not inhabitable, so therefore losses would arise on those points when it's expressly stated out or set out. So certainly losses are recoverable on that point.
Okay, that's great. Thanks very much, Henry. That's lots of questions that you've answered there. So hopefully people have now got the information that they need. Don't forget, you can always email Henry, Henry Hathaway at silverllp.com if there's something more specific you would like to know or in relation to a specific project or issue. Other than that, your CPD certificates will be out in the next couple of days, and we look forward to seeing you at one of our upcoming seminars. June's dates are now online, and you can book away to your little heart's content. So hopefully we'll see you all again soon, and stay safe, everybody. Thank you. Thanks, Henry. Thanks, Lucy.
Thank you.